Welcome to episode 4 in the second season of Justice Center Weekly, a podcast from the Justice Center for Constitutional Freedoms. I'm your host, Kevin Steele, and with us today is lawyer Chris Fleury out of Ontario. Chris is a busy guy. He's been laboring mightily on COVID ticket cases in Canada's most populous province, and that's quite a workload. We'll ask him for an overview of how those things are going, generally. There's been a lot of victories and some defeats. I'm curious to know if he's noticed any trends in the prosecution of these cases as the COVID lockdowns retreat into bitter memory. Off the top, Chris, I want to ask you about an appeal you're filing on behalf of former Ontario Member of Provincial Parliament Randy Hillier. He was pretty active during the lockdowns, still is active. He's been down in Washington, D.C. testifying at the U.S. Senate about Canada's COVID failures. At any rate, Mr. Hillier got more than a few tickets during the lockdowns for standing outside in the fresh air and protesting. So please forgive me if I'm a bit confused. Which ticket or charge is he appealing? And if you'd be so kind, tell us why.
So thank you, Kevin. Thank you for that intro. Mr. Hillier, the majority of the tickets that he faced and continues to face relate to a specific period in Ontario during COVID. So this is approximately April through June of 2021. This is a period where Ontario, for the second time, invoked what it called a stay-at-home order, which is essentially a form of what I would characterize as house arrest. I don't even think I should say essentially. It is house arrest. Every person in Ontario during that period was required to remain at their residence unless they were permitted to leave for one of 29 enumerated purposes. So accessing healthcare, if your occupation was quote unquote essential, then you're permitted to leave. Religious gatherings, limited religious gatherings were one exception, but there was no exception for an outdoor peaceful protest. So Mr. Hillier is charged. The remaining charges that he faces are within five separate jurisdictions, all in Eastern Ontario, and they all relate to this period between about April and June of 2021, where the stay-at-home order was in place. So what Mr. Hillier chose to do was, instead of bringing a charter application in each jurisdiction, which at one point was over 13 jurisdictions he was facing charges in, rather than bringing these separate charter applications, with the consent of the prosecutors, the prosecuting Crown attorneys, he brought one Superior Court challenge with the idea and the acknowledgement that that decision would be binding on the rest of the cases because they are quite similar. The idea being, if the law was constitutional or unconstitutional on the Friday in, say, Cornwall, the same analysis would apply in Smith Falls on the following Monday, something like that. So he's brought that constitutional challenge. As you know, we were unsuccessful at the application stage. So Justice Callahan, the presiding justice, ruled against us. And we're appealing, and that's where we are right now. We've just filed the necessary documents. It's called perfecting an appeal. So we filed our factum and the related documents, and we are expecting to receive a date for the appeal hearing relatively shortly.
Okay, so that factum's public now. Perhaps you could tell us a little bit about the grounds for appeal then.
Sure. So the background is, or I should say off the top, that Mr. Hillier and our legal team, we disagree with a number of different aspects of the decision, of the factual findings, and the conclusion, obviously. So the decision acknowledged that Mr. Hillier's freedom of assembly was infringed by the regulations, but that infringement was reasonable and demonstrably justified, quote unquote, by way of Section 1 of the Charter. So in terms of what a person may appeal and why they may appeal it, factual findings are much more difficult to appeal. They're given deference by the appeal court. And for that reason, we've restricted our appeal to legal errors and specifically within the minimal impairment analysis. So there's a case called, and I assume that your listeners are well familiar with this now, after hearing about many, many different similar cases across the country. But within that analysis of what does reasonable and demonstrably justified mean, the courts have said that one aspect of that is that a particular regulation or law must be minimally impairing. It must not infringe a person's rights more than is reasonably necessary to accomplish whatever the particular goal is. So what happened in this case, if you read the decision, is that the application judge characterizes the infringement of Mr. Hillier's rights as simultaneously being a complete ban of a charter protected activity, or an absolute ban, I believe is the language, and but simultaneously not an absolute ban, because Mr. Hillier is still, at least in theory, he was still able to participate in some types of gatherings and assemblies that are frankly unrelated to his case and his assertion. So he could have, in theory, gone to a religious gathering or a funeral. He could have gathered with, there's a exception for gathering with one other person who does not have any other people in their household. He could have gathered with them. And there are, again, other very limited exceptions which are not applicable or relevant to his case. And in our appeal focuses really on that's an improper consideration within the minimal impairment analysis, that his rights were, it was a total and absolute ban on his ability to assemble outdoors for the purposes of a political protest. And perversely, the point of the protests was to protest the law which prevented Mr. Hillier and the other protesters from protesting.
Okay, that won't impact the appeal, though, the fact of what he was protesting. It's mostly that he was doing this and there was no exception for it. Is that what you're saying? And there should have been an exception, or there should have been an equivalence between the other exceptions and this particular thing. Is that it?
So within the minimal impairment analysis, what courts have said is that if there is a total or absolute ban on a charter protected activity, then the government has a more onerous burden. They must. It's more difficult for it to be reasonable and demonstrably justified where there is an absolute ban. And just to we go through the case law a little bit in our factum, and just to give you an idea of how this would play out in, say, other cases, there's a case from the Supreme Court of Canada called Ramsden, and what happened in that case is that a young man wanted to advertise an upcoming show for his band, but the Peterborough municipality had invoked a total prohibition on postering on any public property in Peterborough. So he chose to put up posters for his upcoming shows for his band, and he was ticketed, and he took his ticket all the way up to the Supreme Court of Canada. And the Supreme Court of Canada in that case characterized it as an absolute ban on a charter protected activity, and they do not engage in any sort of analysis about, well, he could have expressed himself and he could have advertised for his band in any other number of ways that are not prohibited. So, for example, he could have, just off the top of my head, he could have took out a newspaper advertisement. He could have busked downtown and this sort of thing. But that's not the analysis. The analysis is, was the charter protected activity completely prohibited, which they characterize it as being. And in fact, if we applied the application judge's analysis to this, it would go even further and say, well, it's not an absolute ban because Mr. Ramsden could have gone and expressed himself in any other number of ways that are not related to what he wanted to do and not related to protesting. And if you look at other cases from the Supreme Court of Canada, for example, tobacco advertising, one could make the argument that, well, the tobacco advertisers could have just advertised other products. And that's just not how the analysis goes. So we characterize this as a legal error, and that's the primary ground of appeal.
Right. Just to be clear, then, you're saying this prohibition against outdoor protest was an absolute ban, and that's why it's beyond sort of the comparison. Then, is that it?
It's absolutely an absolute ban. It's beyond that. It's virtually the most egregious infringement of the right to assembly that you could imagine outside of literal dictatorships. Um, Persons in Ontario, again, were not permitted to leave their house unless it was justified under one of these 29 exceptions. So, for the most part, assembly was totally prohibited.
Okay. And so these are all provincial tickets, or are they municipal tickets? Just to, I guess, split hairs here. I don't know that it matters, but he was ticketed. So is he paying the fines to the provincial government based on their law, or were these municipalities that were issuing him tickets?
So the tickets, or I should say, the charge itself is a breach of. There are two different regulations that, in some cases, he's charged with breaching, and it varies by jurisdiction.
Mm-hmm.
Generally speaking, he's charged with breaching a regulation made under the Emergency Management and Civil Protection Act, which is an Ontario statute, and then there are regulations, the stay-at-home order underneath that statute, and then Regulation 8220. That also, it's an interrelated regulation which spells out some of the gathering limits, and he's charged with breaching that as well. So they're both provincial regulations and statutes that he's charged with breaching. But to your point, I suppose the prosecution, it varies. In some cases, these charges are prosecuted by prosecutors who are employed by the particular county or the municipality, and in some cases they are um, uh, provincial prosecutors is the wrong word, but prosecutors employed by the provincial government, who are the prosecutors who you would expect would be taking on the much more serious cases, criminal code offenses, and this sort of thing.
Okay, well, that question was a bit of a setup. I wanted to ask you about other charges that he has faced. I noticed in some of our press releases that some charges were dismissed in certain jurisdictions, and I wondered, well, it sounds like they're the same type of charges that he is facing now, so how could he be, have them dismissed in one area and then, they take him all the way in other areas? And of course, later on, I want to ask you about other charges to other people. I know that you've had a lot of ticket cases and you've successfully concluded those. I wondered if any of those would relate to this type of thing. In other words, does this seem like he's being prosecuted where other people have been let off? That's kind of where I'm going.
So, Mr. Hillier was charged with related to protests that occurred all across the province.
Right.
As you correctly note, many of them were either stayed or withdrawn. So the charges that are remaining against Mr. Hillier um, are all, there are five separate sets of charges in five jurisdictions, all in Eastern Ontario and all in relatively close proximity to Lanark County, which is where he resides and where he was a member of parliament for many years, a member of provincial parliament for many years. The charges that are less close in terms of proximity, so from southwestern Ontario, Toronto, Barrie, and so forth, those have all been withdrawn or stayed by the prosecution.
Does that have any effect on the appeal at all? The fact that you can point to these other charges and say, well, he got let off over here, and so what's going on over here? Is this some kind of unequal treatment, et cetera, et cetera? Do you say things like that in the appeal, or does it not factor into here?
So in the appeal, the only two charges that are at issue in the appeal are the Cornwall and the Kemptville charges, which are again the closest to Lanark County where he resides. He chose to make those an issue on the appeal with the idea that the rest of the charges would be bound by whatever the decision is. Um, is consistency a question that I have raised with the various prosecutors? It certainly is. And quite frankly, it's been frustrating to deal with in terms of the um, differing positions that different prosecutors have taken on these charges, and not just Mr. Hillier's charges, but the many, many other sorts of charges. Usually, prosecutorial discretion. I'm absolutely in favor of that. In most cases, it's a great idea for prosecutors to have discretion in how they deal with charges, because charges are different, accused people are different, and in most cases that helps the system function. In this case, though, with these um, COVID type tickets, um, we've seen wildly different positions in terms of the quantum of the potential fine that could be imposed, and also whether it's just stayed, whether it's withdrawn, whether the Crown is asking for some sort of charitable donation or community service to be made before those things happen. There's just been very, very different positions taken among different prosecutors among the province.
But there's been no challenge to the law itself on constitutional grounds. Is that what I'm picking up here? That this is sort of the first constitutional challenge to that law? In other words, the other ones were dealt with in different ways, or has there been case law on this already, I guess?
So, Mr. Hillier's challenge, he is the only individual who has challenged the stay at home order. He's the
Okay.
only individual in Ontario who has questioned the constitutionality of that particular order.
Okay. And the other orders, other charges, or is this all related to the stay at homes? It's not related to the protests itself. Or I just want to be clear here that he is the one guy that is challenging these orders now. It's taken it to this level, and all these other cases that you've resolved, mostly successfully, have not gone to the challenge phase or the appeal phase, where you're dealing with constitutionality.
Right. So, we may be talking about two different sets of cases. I've represented
Okay.
individuals who were religious leaders in Ontario, and that question of the constitutionality as it relates to religious gatherings, that has been determined in a case called Trinity Bible Chapel. It went all the way up to the Supreme Court of Canada, and ultimately leave was denied. So that's sort of a separate question that absolutely we can talk about if you'd like. And then there is the protesters who I represent, who are some of whom are well known, some of whom are not well known at all. They're just private individuals. In virtually all of the cases, and I'd have to go through, I can't um, say for certain without looking back at every single case, but uh,
Mm.
virtually all of them were either withdrawn or stayed, either outright or upon a charitable donation being made, or a community service being undertaken, and that sort of arrangement.
So it ended rather abruptly. It didn't go into argument phase. It was kind of negotiated, and that was it. That's so. This is actually kind of significant. I guess that's what I'm trying to understand with the appeal here. This is taking the orders to court now, and decisions will have to be made on this.
Absolutely. Again, this is the only constitutional challenge as it relates to the stay-at-home order, and as it relates
Mm.
to freedom of assembly. So that Trinity Bible Chapel case, that was restricted only to religious freedom, whereas Mr. Hillier is raising the issue of his freedom of assembly, that both himself and all Ontarians were not permitted to leave their homes for the purposes of a political protest. So when I say prosecuted under the stay-at-home order, it's a violation. The argument goes that it would be a violation of the stay-at-home order to leave one's house for the purposes of a political protest. If Mr. Hillier were, for example, walking his dog or exercising, or doing one of these other 29 enumerated grounds, then that would be permissible.
Right. How about expression in here? Because we are talking about political protests. You talk about assembly, but is freedom of speech referenced as well in your appeal?
So that was a ground that was initially raised at the application stage. When submissions were made, when we actually went before the court, a difficult decision was made to drop that ground of appeal, to force the the court to deal only with the issue of freedom of assembly. And what we've seen across Canada is that the question of assembly tends to be subsumed within the other rights that are being adjudicated. So, for example, if freedom of expression or religion is, say, that's the issue, as we've seen not in Ontario so much, but across Canada, then courts tend to not engage with the assembly issue, which in our position was the most egregious violation of Mr. Hillier's rights. So we made a difficult decision to abandon that particular ground and to focus our efforts entirely on the freedom of assembly.
Okay. Now, you did answer some of my questions regarding trends in cases by telling me earlier that a lot of these cases were resolved, either by dismissing the charges or some kind of small negotiated settlement, whether it's community service or something like that. Do you see any other trends here in all these cases that you're dealing with? I looked at the Justice Center sheet, and your name is on a lot of cases. So I was wondering, is that the only significant thing you notice, that they don't seem to be going to court, or are there other similarities between them?
So the vast majority of these cases that involve alleged breaches of provincial legislation, the vast majority of them are winding down. I expect that you'll hear about more charges that are stayed next month, and Kevin, you'll be the first to know about that. But other than Mr. Hillier, the vast majority are winding down. The tickets that we're still seeing prosecuted and the tickets that are there's no offer of a stay or withdrawal or charitable donation or any of this sort of thing, are the Quarantine Act cases, which are still being prosecuted. So those are, right now, what we're seeing are the I call them the ArriveCan cases. So a failure to download the ArriveCan app and use it, a failure to provide a place of quarantine or to provide their vaccination status. So those charges are still ongoing. We're still seeing many of those charges being brought and trial dates set. And we do have, I am involved, and the Justice Center is involved in a constitutional challenge related to ArriveCan and the Quarantine Act.
Are all the Quarantine Act cases ArriveCan sort of centered? That's what I'm wondering. Are there separate quarantine cases that are not? So when we talk about the quarantine cases, we're always talking about the ArriveCan app?
Right now, so it's evolved over time. So in 2021, there were Quarantine Act requirements for individuals who were coming across the border from international travel. In 2021, every single person coming back from international travel had to quarantine. Most of those cases, to my knowledge, have made their way through the courts. So I'm not involved in any of those cases that relate to things happening in 2021. In 2022, that's when we see ArriveCan. That's when ArriveCan is brought about. That's when we see the requirement, I'd say most concerningly, for unvaccinated individuals to quarantine, whereas vaccinated individuals did not have to quarantine. So it's just a matter of timing that these 2022 cases are now actually being brought before the courts, whereas other cases that relate to other requirements in the past, those have already more or less made their way through the courts.
Okay. Could you ballpark how many of those ArriveCan app cases there are? I know it's an unfair question because I didn't ask you to count them up before you got on here. But, could you ballpark how many are we looking at? Because it is a big issue right now. ArriveCan is so much in the news due to the scandal involving the cost of the thing. I just wonder how many ArriveCan cases we have.
There are two that we're retained on, where we are bringing a constitutional challenge. And there are, I would say, two more that we expect to be retained on. And there are a number of other individuals who have reached out.
Okay. And one last question. I guess I should have stuffed this into the Hillier section, but what's the timeline on that? Do you have dates yet? I know that you filed and you told us about the documents filed. Have you got any court dates yet, or is this still to be determined?
No, we perfected our appeal last week, so we expect to hear back from the court relatively shortly. I would say within about 6 months, we should have our appeal date inside of the next 6 months or so, but that is determined by the court, by our legal team schedule and the Crown schedule as well. But I would expect it would be within the next 6 months or so.
Okay, great. Well, thanks, Chris, for coming on. I know you're a busy guy. Like I say, I've looked at the sheet, and your name is everywhere all over these COVID ticket cases. So thanks so much for taking the time to fill us in, and I hope to have you on again soon.
Thanks, Kevin. It's always a pleasure.